Okay, so welcome everyone. Our presentation today is Maryland's new alternative to guardianship, supported decision making. And we have three speakers today. They will introduce themselves a little bit more, but Megan Rosciano with the ARC. We have Randy Ames with Disability Rights Maryland, and Sandy Ballin also with Disability Rights Maryland. So thank you for joining us and welcome everybody in the audience. And I believe what we're going to do is please put your questions into chat and we will take them as we go through and possibly much of it at the end. We're trying to get as much information as we can to everybody as possible. So with that, I'm going to turn it over to Megan.
Hi, everybody. Thanks for joining us this evening, and thanks to Pathfinders for Autism for having us. As Trish said, I'm Megan Rosciano. I'm a senior staff attorney at the ARC of the United States. I'll turn it over to Randy and Sandy just to introduce themselves real quick.
Good evening, everyone. My name is Randy Ames. I'm a managing attorney with Disability Rights Maryland. If you're not familiar with Disability Rights Maryland or DRM, we are the statewide advocacy agency advocating on behalf of people with disabilities. And thank you. I'll just piggyback on Megan and also say thank you to everyone for participating. We know it's after hours and we're excited to be here.
Good evening, everyone. My name is Sandy Ballin, and I am a staff attorney at Disability Rights Maryland, and I'm happy to be here, and thank you for having us.
All right, so we'll jump right in. We're going to talk a little bit about background first. We're going to talk about what supported decision-making is, why it's important, how it works with other alternatives to guardianship, and some examples of how it works in practice. So as far as background, when I have a bit more time, I usually go more in depth in this slide, but I think that when we before we talk about guardianship, alternatives to guardianship, supported decision-making, I think it's important to kind of realize the history of where we are in the disability rights movement, as far as where disability civil rights law is, and to recognize that while there have been a lot of advances, we actually aren't that far. If you look back at a lot of the major victories in the civil rights arena, people with disabilities, especially people with cognitive disabilities, have been left out. If you look at things, like the Civil Rights Act passed in 1964, it didn't include people with disabilities. It covered kind of everybody else, but didn't include folks with disabilities. And it wasn't until 1973 we got the Rehabilitation Act, that there was a national civil rights statute for people with disabilities. And actually, it wasn't until 1977 until that law had regulations that actually had some teeth to it. Of course, it's not until 1990 that we get the ADA itself. So I really kind of, when I have more time, talk through this slide and talk through how kind of at those critical junctures, folks with disabilities have been left out. So when we talk about decision-making capacity, a person's ability to kind of make those decisions, I think it's important for us to recognize that historically as a society, we haven't been so great about including people with disabilities and giving them those opportunities. So I think that that's, a lot of the bias that we're up against when we talk about really respecting what people with disabilities say, their decisions, their choices, and I always think it's a good thing for us just to start with and remind folks on. So what is decision-making capacity? That's in a person's ability to make decisions, right? And it exists on a spectrum that can vary depending on the context. So there are some decisions that a person might need less support with. That's going to be contextual, could depend on the decision, the person, the time of day. If you ask me what I want for breakfast and I'm really hungry, it's probably easier for me to make that decision of what I want because I'm hungry and I'm going to be motivated to do that. But if you're asking me to do complex financial planning and it's, early in the morning, I haven't had my coffee yet, I'm going to need a lot more support to make that decision. That decision is going to be tougher for me. And that's just the way decision-making ability and capacity is for everybody. whether or not you have a disability or not. So some decisions are in the middle, some decisions you need less support with, some decisions you need more support with. What's important to remember is that that's individualized to every single person, their strengths, their weaknesses. So it's something we should be looking at when we look at a person's ability to make their own decisions. So I can, make my own decisions. I can decide that I want chocolate chip cookies every single day for every single meal for the rest of my life. But do I have the legal capacity? Do I have the legal ability to make that decision? That's a different concept, a different idea. So again, I can decide I want chocolate chip cookies all the time, but am I allowed to, can I go out and buy the chocolate chip cookies? Can I spend that money? Am I allowed to make those dietary decisions for myself? That's legal capacity, right? And so legal capacity is kind of a legal construct, a legal idea that recognizes that a person can make their own decisions under law. So I can decide I want to move to a new apartment, but do I have the legal capacity to sign a lease? Is, the landlord going to accept my signature on that lease? Can I understand that? That's a legal question. Every adult, whether or not they have a disability, is presumed to have legal capacity. And if a person has legal capacity, then their decisions are recognized under law. I think it's just important, again, to kind of pause and think a little bit about kind of discrimination in the history of, whether or not folks with disabilities have legal capacity, right? Go back to that first slide on the history of the disability rights movement. Historically, we haven't presumed that people with disabilities are able to make their own decisions. They've been segregated in institutions. They've been segregated in schools. They haven't been allowed in schools. That was all fights that, advocates had to go through to get folks included. People have been unable to vote. So again, when we talk about this, kind of have to be aware, don't want to get too rosy-eyed. The reality is, we're up against kind of a tough tide and trying to change those expectations, those assumptions about people with disabilities. When a person is not found to have legal capacity, is usually when they're vulnerable to being placed under guardianship. Under guardianship, a person loses the ability to make certain decisions for themselves, and that power is given to a guardian. Guardianship is a formal legal process before the court. It's, some people kind of forget that the court's the ultimate guardian. So at the end of the day, the court can decide if you're, the agent, if you're the guardian, that they don't like you, and remove you. So it's a formal court process. It's expensive. It can be very hard to get out of once you're, once you're subject to it. And so I think it's again important for folks to kind of know that generally about guardianship. It's definitely a tool in the toolbox. We're not here today to tell you it's not, or it's wrong all the time. We just want to underscore that maybe it's the first thing people jump to, and maybe we should look at other options because it is something that's far more restrictive. And then there are two types of guardianship in Maryland: person, which deals with personal decisions, healthcare decisions, and property, which is going to deal with financial decisions. So some of the kind of questions, this was kind of the landscape, guardianship being the go-to. And so some of the things that we started to think about was, what if with certain supports and accommodations, some people with disabilities can actually make their own decisions and not need a guardian? So, I think that the growth of assistive technology is a great example, right? We assumed that, how many, 25, 30 years ago, that certain people were completely unable to communicate. And then iPads came along and speech generating technology came along. And all of a sudden, these people have amazing voices and are shaping the laws in our state, and are doing incredible advocacy work. So what if with those kinds of supports, with certain, if it's a quiet setting, or if it's additional time, or if it's somebody to translate how somebody's communicating, if that's an eye gaze or words or gestures, however it is. What if that person may not need a guardian or may not need a guardian to make all decisions for them, just some? So that's what the Cross Disability Supported Decision Making Coalition, which we established, was really focused on, and it was over 27 partners, including folks from the Maryland courts and state agencies, advocacy groups, folks with disabilities came together to create an action plan for, how we can really implement alternatives to guardianship like supported decision making. And the coalition helped pass a law. It was passed in October of it went into effect in October 2022. So over a year ago now, that formally recognized supported decision-making as an alternative. So that's what we're here to talk about today. I'm going to turn it over now to Randy to talk a little bit about what supported decision-making is and how it works in Maryland.
Thanks, Megan. So just building off of the framework and background that Megan provided us, thinking about why supported decision-making, how it came to be, I want to just kind of go through some basics and kind of the foundation of what it is. So in, the most kind of simple term, under the law now, supported decision-making is recognized as a less restrictive alternative to guardianship, that allows a person to keep their decision-making authority without appointing someone else to make decisions for them, like a surrogate. So again, it's the purpose of it is, a less restrictive alternative to guardianship under the law. Judges must take SDM or supported decision-making in consideration in guardianship proceedings. And supported decision-making in kind of its most broad kind of general form is a reasonable accommodation under the ADA, the Americans with Disabilities Act. So, we've had questions about, well, what if, I move or I'm in a state that doesn't recognize supported decision-making, people with disabilities still have that fundamental right to a reasonable accommodation request. So supported decision-making in some form, informally should be followed throughout the US. Next slide. So how does it work? So, thinking about your day-to-day life and in making decisions, some can be, more simple day-to-day decisions like what I'm going to eat, what's for dinner, what I'm going to wear, versus a more complex, maybe life-changing decision. On either kind of decision, right? We use our friends, our family, to get, their input, help talk through issues, and support us. And so supported decision-making is really formalizing that process that we all do and having our team around us. So Disability Rights Maryland, when Megan Rusiano was still with our office, just as an example, I think highlighting supported decision-making and the need for it, but also the fact that this advocacy around supported decision-making, was taking place over the pandemic. And I think we unintentionally had this prime example of the need for supported decision-making in Maryland. And that was over the pandemic, Disability Rights Maryland, we were receiving numerous complaints and calls regarding different health facilities refusing to accommodate people with disabilities and having family members, trusted friends, supporters, visit them if they were admitted into the hospital or attend appointments with them in person. And so we were able to advocate for the Department of Health and the Department of Disabilities to issue this guidance to facilities, hospitals and community settings, to ensure that people with disabilities are allowed to have that reasonable accommodation request, that informal supported decision-making, but that can also be formalized in a written agreement. We'll talk more about that, but just to kind of give, highlight a real life example of how supported decision-making can work. Next slide. So, Maryland has this new supported decision-making law that went into effect last October. It's only been a year, and people are still learning about it. We're still doing this kind of outreach and education about it. So again, supported decision-making, it can be informal or formal. And that's where the informal is, again, that team that you have around you, a situation like somebody may ask for their support person to attend an informal meeting with them, and there may not be any issue of confidential information, or maybe the person is looking for support in a more sensitive or confidential meeting, for instance, with an attorney, where that attorney or a provider may want a more formalized agreement, or potentially a release of information in order for that person to be there. But the supporter, just in having a supporter, that person, the decision maker, is not releasing or consenting to have their information released to that supporter, separate from whatever conversation is happening in real time, without an additional consent that would be applied in the future. And so again, SDM, it's required now to be considered as a less restrictive alternative before guardianship order can be placed or issued by the court. A person under guardianship can still use supported decision-making, and that is to more clearly define areas where they can make decisions for themselves, or potentially end the guardianship. So again, it can be informally, and we'll get more into this, a formal supported decision-making agreement. And again, just to kind of define the role of the supporter, they're there, think of them as an interpreter, right? Or the person there to help prompt the individual in making their own decision. That supporter is not there to step in the person's shoes. They're there to make sure that the person's wishes are being communicated and understood, and that information is understood between all parties involved. So the supporter is not there to enforce the person's decisions, or again have access to information separate from any individual conversation, and can't go back and afterwards. It's just there to ensure that the individual is making is able to make an effective decision, and that may at times require requesting additional information, requesting something be in writing versus to follow up, or rather than a telephone or verbal in-person meeting. Next slide. So again, more into Maryland's new supported decision-making law and how it works with folks that are already under guardianship or may have a power of attorney. And so just for some additional context, the manner in which a person communicates is not grounds for saying that they cannot make a supported decision-making agreement. However they communicate needs to be accommodated to ensure that if they identify that they need support and they've identified a supporter, that should be provided. Again, that role of that supporter to be an interpreter, again, help keep the conversation, prompt the person if they need reminders, whatever that may be. And so in speaking specifically in guardianship and powers of attorney, a person under guardianship can use supported decision-making, again, informally or formally, to assert their decision-making authority and their ability, which could lead to the termination or reduction of a guardianship order. When a supported decision supported decision-making agreement impacts the guardianship authority or any authority given under a guardianship order, that supported decision-making agreement has to be limited to the areas that are not already covered under that good guardianship order. So there may need to be good cause for the agreement. Again, it may require going back to the court to amend or clarify a question that a guardianship order raised. Finally, a supported decision agreement does not impact the authority of any agent under a power of attorney. A power of attorney could also be the same person that a person identifies as their supporter. But, you know, if they're a separate person, the power of attorney or guardian, they need to be provided a copy of the supported decision-making agreement, just to ensure that everyone is kind of aware of the different roles folks are playing. Okay, and next slide. So we're going to talk a little bit more about the specifics of what needs to go into a supported decision-making agreement in Maryland. So for, you know, kind of best practices, it should be documented in writing and dated. So again, the form of a writing itself, if somebody decides to formalize a supported decision-making agreement in Maryland, these are the requirements. So, you know, you need to identify the supporter, describe how that supporter will work with the person, identifying them as a supporter, you know, address any actual or perceived conflicts of interest, and then state that the supporter, you know, that there are clear limitations on the supporter's access to the person's confidential information, and that it does not affect the authority of an agent under a power of attorney. And then a supported decision-making agreement must be signed and witnessed by 2 adults who are not the supporters or an employee of an employee or agent of the supporter. And so we've provided the link here. Disability Rights Maryland's website has a sample Word document that you can kind of go through, tweak, change, and work with. So I do recommend that folks take, when they have an opportunity, to review the sample agreement.
So Renee, we just had 2 questions.
Sorry.
Yeah, I think they came to me. So I think we could just answer them pursuant to this slide if that works. One of them was whether or not you had to file a supported decision-making agreement with a court, and if so, what court? And the beauty of it is that you don't. You don't have to file it with a court unless you know, if you are a guardian and it impacts your authority, the guardian's authority, then you have to get the court's permission because the court's the ultimate guardian. But otherwise, there's no need to file it with any court. The second question was whether or not a supporter could be reimbursed for their time. You know, that's something that's not precluded. Actually, Randy, I'll let you talk about that, I think, on the next slide of who a supporter can't be. And that list does not include paid staff. So paid staff can be a supporter, but I'll turn it back over to you.
Megan. So yeah, and sorry, I felt like that question prompted something. It'll come back to me late in the day. So, you know, supported decision-making agreements in Maryland. Oh, I remembered what it was. So I just want to also highlight, again, in entering a supported decision-making agreement, it's supposed to be accessible. It's supposed to be a process, again, that can be formalized easily by folks. And so while it, you know, it doesn't need to be filed with any courts, you know, it can be provided to medical providers, banks as needed, or if, you know, a question comes up about a supporter being involved, but also it does not require an attorney. Doesn't require, you know, anything but 2 adults to witness along with the person identifying the supporter and, you know, entering the agreement, signing and dating it. So it doesn't require any additional, you know, anything to be recognized under law, as long as there's the applicable two witnesses.
It doesn't require a notary, which was just another question. It doesn't-
So, yeah, so circling back to the current slide, talking about who, the kind of more of the requirements of a supported decision-making agreement. So, a provider such as a DDA provider, an adult medical daycare program, cannot require a supported decision-making agreement in order for somebody to participate in a program, activity, or access a service. So again, a requirement that somebody have a supporter kind of goes directly against the purpose is choice, right? Empowering the person to choose if they want to have a supporter in the room. So it cannot be a requirement. And then the person can appoint any of the following supporters except for a minor. And so again, you can't, you know, making decisions and kind of the confidential nature sometimes of communications and the age of majority and having legal capacity kind of leads to why a minor can't enter into a supported decision-making agreement. Also, a supporter cannot be a person that the person has a protective or a peace order against, right? So if the person is not allowed near or to communicate with each other, it doesn't make sense that they would then act as the person's supporter. And then a person that has been convicted of financial exploitation. Again, that's to ensure, that provision is to ensure, you know, that a person identifying a supporter is not somehow financially exploited or abused because of them having that supporter in place. And then, so the supporter's role, again, the supporter is not in the room to make the decision for the person. They're also not liable for the decisions that the person makes, so long as they act in accordance with the supported decision-making law and in compliance with their role under the agreement. Again, it's not what's in the person's best interest. It's not, you know, telling a person what they should decide. They're there to support them, to ensure that the person's will and preferences are followed. They have an obligation to act honestly, diligently, and in good faith and avoid conflicts of interest. They may maintain information, including how they support the person and how the person communicates. And then they don't make decisions, again, for the person. They're not there to exert their you know, individual influence or coerce the person into a particular decision. So yeah, so with that, I will stop and I'm going to turn it over to Megan to discuss some tools supporters may use.
Thanks, Randy. And I know that we have some questions. I just want folks to know we will get to them. I'm keeping track and we'll respond. So I think, you know, when we think about some tools that a supporter might use, again, a supporter is there to really, Randy said, interpret, translate a person's wishes or preferences. The idea behind it, of course, is that the people closest to a person know them best, right? My partner knows me best. My best friends know me best. They can tell before anybody else in the room when I'm anxious, when I'm upset. And so really, if we give power to those relationships and those people who know a person the best, you know, we can make sure that somebody's comfortable, that they're able to make decisions, and that, you know, to the extent that they can, that their will and preference is respected. So that's really what it's all about. So what a supporter might do, They might provide plain language materials or information for a person. So, right, so much of our lives is not in plain language, right? You go to an attorney's office, you probably look at these slides in this PowerPoint and you say, I don't understand what this means, right? It's supposed to be in plain language, it's supposed to be in a way that people can understand. You go to the doctor's office and they talk a mile a minute. And then they leave within 5 minutes and you don't have any idea what they said. Maybe a supporter can help translate, ask for extra time, maybe ask the doctor to follow up with an email summarizing what it was, translate those notes into a way the person can understand. We privilege spoken word, we privilege written word to communicate. That's not the only way that people communicate. And so, to the extent that supporters can be that intermediary and translate between a professional and the person, that's their role. Even if a person can't, doesn't have, we don't have a lot of ability to understand how they communicate or what they're saying, making sure that, they're included to the most extent that they can, and that you're checking in if it's with reading gestures or reading reactions to make sure that what's going on, something they're involved in. A supporter might advocate for extra time, help a person make a list of pros and cons, role play some activities, right? Sometimes before I have a big meeting or an appointment or something, I'll think through what I want to say, right? I'll think it out and I'll realize, okay, we're gonna have 5 minutes to ask these questions. Let's practice. Let's make sure it rolls off your tongue real nice so that you can get out what you want to say. And that's, the person who prompts me to do that would be doing supported decision-making with me. There are a bunch of tools. It's really fun to see the proliferation of tools on supported decision-making across the country. It included a link. Of course, the slides will be shared, I hope. It's called the Stop, Look, and Listen tool. It's developed by the South Carolina Supported Decision-Making Project. And what it is a stoplight. So red, yellow, and green. Red is decisions that a person hasn't been given the opportunity to make. So we don't know if they can make themselves. Yellow is they've had some practice. And green is, they're able to make these decisions. And the tool itself breaks out specific decisions and instances. It's a great chart. So I encourage folks to look at that. The Arc of Northern Virginia also has 100 ways to use supported decision-making, which are really creative and great. So I encourage you to look at those, big and small. They're little examples. So when we talk about some safeguards while using supported decision-making, sometimes people get worried. My goodness, what's going to happen? This person is going to take advantage of someone. I'm concerned about that. That's an analysis. We're not here to say this is going to work in every single situation, but there are some safeguards that were built into the law. So of course, there's limitations on who can be a supporter, as Randy went over. You should identify conflicts of interest and a plan to mitigate or address those conflicts. So we all have conflicts of interest in our lives. An example might be if somebody has a job coach and they want to identify that person as a supporter to help them with employment decisions, but they also want to leave their job, right? That job coach has a bit of a conflict, right? Because their job is contingent upon being in that job with that person. It doesn't mean that they can't be a supporter, but maybe we think about some ways to address that conflict. Maybe that person's only involved in certain decisions. Maybe there's another person that kind of acts as a monitor. Maybe you have two people be a supporter for that type of decision. It's not prescriptive. There's not anything that you have to do. You just kind of have to think about how you address those conflicts. Because they do exist in our lives. And something that we heard from people with disabilities when we were passing this law is that, you get to choose, people without disabilities get to choose who they want to be their informal supporters all the time, without these kinds of restrictions. And so, why shouldn't we? And so I think that point was well taken. there are limits of liability for professionals who, in good faith, honor decisions made using supported decision-making agreements. So, a doctor, they're worried about licensure issues of, hey, if I rely on, this agreement or this supporter who's telling me that this person is saying this, if they rely on it in good faith, they don't have to worry about that liability. Same thing if they refuse to honor it in good faith. If they think the supporter's overstepping their bounds. A guardian whose authority is not impacted by a supported decision-making agreement really shouldn't prevent a person from entering into one without good cause. So again, it all depends on what's in a guardianship order. Something that we had seen in different universes was, a guardian who might say, I have the ability to make all these decisions for the person, and I'm going to do that. When really their decision-making ability was limited in some way. And you want that person, if that person can make their own decisions, to be able to do that. And so a guardian shouldn't get in the way where they don't have good cause. And again, probably the most important thing, and especially something that was important to attorneys who were working on this with us, was supporter can't make decisions for an adult. Unlike, a power of attorney, we'll talk about how this works with powers of attorney in a bit, because I know there's a question about that. A supporter can't go into the bank and empty a person's bank account. You can't go to the doctor and say, this person needs that surgery tomorrow. That's just not what this alternative or tool is about. There's other alternatives we'll mention that do that, but this is not one of them. So there's not that authority that comes with being a supporter. So I know there was one question of kind of how supported decision-making informally is different than kind of circles of supporter things that informally people do. So something that, when we looked at this legislation, a lot of states have laws recognizing supported decision-making agreements and say what has to be in those agreements, right? It's very prescriptive. Maryland, you have that option to create an agreement. There are some pros of that. It's easier to get third parties to listen when it's on a piece of paper signed by people and it looks professional. That's just the way of the world. It also helps more clearly identify supporters' roles and what kind of support they will provide. But one of the reasons why we opted to have an option to use an agreement or not was because, as Randy said, we see supported decision-making as a reasonable accommodation under the Americans with Disabilities Act. And there's no limits. We didn't want to make something that was kind of conflicted with the ADA, right? The ADA doesn't have these kinds of limitations of you have to put it in an agreement and you have to do this. And, there's not that same requirement. There's a requirement to request an accommodation, but that's much simpler. I think that a lot of the use of supported decision-making probably happens informally. If you want somebody just to attend a doctor's appointment with you, if it's going to be an important surgery, maybe you don't need a formal agreement to lay that out. If it's not going to be ongoing, it'd be kind of temporary. It's less prescriptive. It's the people who've, I relied on formally in my life to help me make decisions 5 years ago are much different than the people I rely on now, right? It's very hard to plan that far in advance. And so informal supported decision-making has its benefits. Some professionals, paid staff might be more comfortable acting as a supporter if they don't have to sign an agreement. So those are some pros and cons, but I think, you look at informal use of supported decision-making, it's a lot of what's going on already, right? There really isn't a lot of difference in supporting folks in team meetings and how that's done. The roles of some staff, paid staff, and being supporters on certain things. I think that that's just what's happening in the world, and we didn't want to preclude or say that that's not, you have to make an agreement for that to be recognized. So I'm going to turn it over to Sandy to talk a little bit about why supported decision-making is important.
So we've obviously just discussed what supported decision-making is and the different tools that you can use. And the importance of supported decision-making is really rooted in the impact of guardianship. So when a person is placed under guardianship, they lose a lot of their legal authority to make a lot of decisions for themselves. And that can include the ability to vote, the ability to marry, and the ability to direct their own healthcare and make their own healthcare decisions. And even though the guardianship order appoints a specific guardian, the court is the ultimate guardian in that they decide essentially what rights are going to be restricted. And guardianship is too often plenary and permanent. And when an individual wants to end the guardianship, they face barriers to the restoration. And you can see that even through the Free Britney movement, where pop star Britney Spears was having difficulty ending the conservatorship that her father had over her, where he was able to control a lot of her financials and a lot of her personal decisions. And when an individual wants to restore their rights, they have difficulty obtaining legal counsel to represent them in the termination proceedings. They have inability to access their medical records that can be used as evidence in the proceedings. And more importantly, there is also the bias or stereotypes about their own capacity. And that can even be seen in the legal relationship between the attorney and the client. Some attorneys in guardianship proceedings were using their client's diminished capacity or their client's disability as justification for substituting what the attorney believed was right for the client and in not focusing on what the client actually wanted. And actually, because of that, within Maryland, the ethics rules for attorneys has been changed so that attorneys are now obligated to the best of their ability to maintain a typical attorney-client relationship with individuals with diminished capacity. So essentially, they have to focus on what the client wants instead of substituting what they believe is the best. And also the rule does recognize that supported decision-making and other supports and accommodations can be used through the attorney-client relationship. Next slide. And so people with disabilities are regularly subject to the unnecessary and overbroad guardianships that sometimes are rooted in the bias. And so there's the belief sometimes that the evidence of the need for supports is proof of incapacity. And of course, that's not the case. Just because an individual needs supports does not mean that there's evidence of incapacity. And the issues with that arise from guardianship is really why SDM is important, because it respects the people's voices and choices, regardless of their communication style, their age, or their diagnosis and disability. And it also helps a person develop and maintain advocacy, self-determination, and decision-making skills over time. And it also promotes the idea that you don't go automatically towards guardianship. You start with the less restrictive alternatives like SDM, and then move towards the more restrictive options if absolutely necessary. And the other nice thing about SDM is that you can use it now to help plan with it for any future needs that there might be down the road. And the importance of SDM and self-determination is important because studies show that people who exercise greater self-determination have improved life outcomes. So that can be living independently. They work in the community at higher paying jobs and make greater advances in employment. They're more likely to identify situations where they could be abused, and they're also less likely to suffer abuse. They also have greater financial independence and better money managing skills. And they also have greater community integration. So SDM is important in that it promotes that greater self-determination that essentially helps individuals have those better life outcomes. Now I will turn it to Randy to discuss how it works with other alternatives.
Thanks, Sandy. Okay, so I'm just gonna touch on all other alternatives to guardianship. And so, you know, guardianship, again, it can be of the person or property. And so these alternatives, we broke them down for financial, which would be, in line with avoiding guardianship of property, and then personal, which would address a potential petition for guardianship of person. And so for financial decisions, Social Security beneficiaries can utilize a representative payee, somebody to help them manage their finances. Additionally, in Maryland, there are ABLE accounts that people can distribute assets and funds into, and they can have somebody assist them in administering that account or utilizing that account. Again, simple kind of workarounds of problems, something as simple as direct deposit or automated payments. If somebody only has, SSI and they have, DDA services in place, for example, the need for financial power of attorney can be, can require or include a host of authority that just isn't applicable to that person, but rather these kind of basic alternatives can be a workaround rather than seeking guardianship. Again, powers of attorney in Maryland, those are limited to financial decisions. So again, having that surrogate if the person so chooses. There can be petitions for specific transactions. Again, that would be, this would be through a guardianship petition, but a limited request for a financial transaction that would either help resolve the petition for guardianship or, bring to light pertinent facts. Additionally, there's special needs trust and special needs trust that can be established for a person with a disability. And lastly, again, limited guardianship in and of itself. So even if a guardianship order has already been in place or will be, limiting that to the best of the person's ability as it relates to their capacity to make financial decisions. On the other side, again, personal decisions, we're talking about things like medical decisions. That could be an alternative to that would be the use of an advanced medical directive, a surrogate decision maker. Again, appointing that person, it could be separate from an advanced directive or as part of an advanced directive. And then when it comes to medical decisions, preemptively documenting their wishes, for example, as it relates to life-sustaining treatment under a MOLST form. Similarly, again, a limited guardianship is an option, again, to kind of frame the order to be as specific as possible to the individual's capacity and ensuring that they retain the authority wherever possible. Additionally, person-centered planning. So somebody who has services or maybe a caseworker, having that planning be as specific to the person's needs and detailed can alleviate the need for a guardian, right? If that person is able to communicate their wishes or work with a case manager, a coordinator of community services or supports planner, that may be sufficient if there's been an issue of, potentially self-neglect or something that can be resolved. And again, informal support. So as we've been discussing with supported decision-making, that could be, again, your formalized or informal supports, again, through a supported decision-making agreement or separate. And I apologize, I'm just having a little dryness. So I'm going to turn it back over to Megan to provide some examples of how supported decision-making can work alongside alternatives to guardianship.
Great. Thank you so much, Randy. So, I think that this gets to, and sorry, I saw that there was a question that popped up that says, what is surrogate decision-making? So surrogate decision-making, there's a statute in Maryland. If somebody is unable to make medical decision for themselves. There's a list of people in an order of priority that can make that decision for them in the medical context only. So first on the list, if you have it, is I think a guardian or a power of attorney. If you don't have one, then it moves to a spouse. If you don't have a spouse, it moves to an adult child. If you don't have a adult child, it moves to your parents. If you don't have parents aren't living or they're unavailable, moves to a sibling. And then last on the list is friend, which there's some additional requirements. But it's a great alternative. I know a lot of folks in Maryland with more significant disabilities actually don't end up under guardianship. They use surrogate decision making. They have a surrogate decision maker for healthcare decisions, and they have a representative payee for financial decisions. So it's a great alternative for folks that allows for someone to still make a medical decision for that person. Ironically, actually, surrogates have more power than guardians in some cases. Actually, sadly, but related to end of life care, a guardian is going to have to go to the court to get permission to help a person get end of life care, whereas a surrogate can make that decision without having to go to the court. So we talk about some examples of how supported decision making works with other alternatives. Let's say you have somebody, a representative payee, a surrogate decision maker, or even a guardian. So what do all those things have in common? They're all people who make a decision for someone else. So if I have any of those things, I've been determined that I cannot make a healthcare decision, I can't manage my funds, and I need a guardian, so I can't make certain decisions for myself. But just because I can't do that doesn't mean that what I have to say or what I think shouldn't be listened to some extent, right? Doesn't mean that I still, to some extent, to the extent that I'm able to communicate preferences or choices, we should try to be cultivating that decision-making skill, because it's a skill that grows across time. So maybe in those circumstances, a representative payee, a surrogate decision maker, or a guardian can use supported decision-making informally to kind of promote a person's ability to make decisions. Like a trial run, see how it goes, talk through decisions, include them in decisions to the extent that they can. It's a great thing to do so that a person, again, can grow across time. Because I think that there's an assumption, well, that person can't make a decision. We still should be trying to include them. That's just good practice, right? And trying to build that skill across time. I know we had a question before the presentation, but supporters can help teach someone who has an ABLE account about how to manage their funds, how to budget, make transactions, maybe get connected to a financial planning course. I think that's a great example. I think ABLE accounts are a wonderful example of how people with disabilities can have some funds to manage, and a supporter is great, to be able to really kind of give advice to somebody in that context. If you have a power of attorney, we had a question about this earlier. So we're talking about a power of attorney, we're talking about financial decisions. If you have a power of attorney, if you have an advanced medical directive, just because you have either of those documents doesn't necessarily mean that you still can't make the decision, right? Everybody should have a power of attorney. Everybody should have an advanced medical directive, regardless. They are tools that everybody should have. But just because I have it, and I do have one, just because I have one doesn't mean that my wife, who's my agent under my power of attorney, should be going to the bank and depleting my bank account without talking to me, right? Because I can still make my own decisions. And just because she has that authority doesn't mean that I still can't make decisions without her, right? And so that idea holds true. Unless I'm unable to make that decision, I still have that ability. And so I may use supported decision-making to help me, with a certain financial transaction, or if I'm talking about an advanced medical directive, I may use somebody else other than her to help me make medical decisions. Right. So there's kind of multiple ways that those two folks can work together. if a person's able to make the decision independently, they can still use a supporter. Maybe that supporter is the agent under a power of attorney. Maybe they're not. If a person can't make the decision, if something's happened and they're unable to make that decision for themselves, then the agent again can kind of try to use it informally to encourage the person, help grow those decision-making skills, making sure that they're included to the extent that they can be. So I know we're a little short on time. We'll go over some quick examples of how to use supported decision-making. Turn it back to Randy real quick.
Thanks, Megan. And sorry, I just want to highlight a couple things and I'll jump into this example, but, kind of thinking about, supported decision-making all the way to guardianship. I think of it as another spectrum, just like decision-making is on a spectrum, right? Needing, more supports, needing less supports. And so, thinking of this as a transition, and we're transition as the person ages or life occurrences. And so ideally supported decision making, if the person wants to formalize it, would be part of an estate planning session, right? That kind of to date and my life forward, what I want and what I want to document. Additionally, I just wanted to highlight that for supported decision making, the person does not have to be a person with a disability. Anyone, I can do a supported decision-making agreement to ensure, maybe there's some kind of support I require where I want to make sure that that's documented. So I just wanted to highlight those two things. So quickly, just the example of a medical appointment, having a big medical procedure coming up and wanting help understanding the recovery and side effects of that procedure, right? So you can have that support person come into the appointment with you, again, helping whatever level of assistance you're comfortable with or the person needs, right? I kind of touched on this before, whether it's more time to make a decision, whether it's, maybe having something in written form, but even in a doctor's office, that supporter can be in there with you during the appointment. And again, for this, you don't need a formal agreement to have this. This kind of conversation, it could be under an informal supported decision-making agreement that's verbally communicated or a reasonable accommodation request. And so with that, I'll turn it over back to Megan.
So just really quickly, you're thinking about what if you have a lot of people want to help you make a decision, how to use supported decision-making with a team. So a supported decision, if you have a team of people you're working with, might be helpful to have an agreement just to lay out people's roles. You can pick your team members and identify how they'll work together. Maybe you want one supporter to help you with everyday medical decisions and another to help with bigger ones. My mom's a nurse. I always bring her in on bigger medical decisions, but I usually talk to my partner about, the everyday kind of stuff. You could kind of break out depending on who has the expertise in your life and who you want to call on. And again, it may be helpful to have an agreement so everybody knows what you want and that you're in the driver's seat. And I'll turn it over to Stanley to go over our last example.
So the last example is about guardianship and if you're under guardianship but want to make some decisions for yourself. So you do have to look at the guardianship order, and your guardian may not have the authority to make every decision for you. And where they don't, that's when you're in the driver's seat and you can use SDM either informally or formally to make your own decision. But that doesn't mean you can't use it if the guardian does have authority. So where your guardian does have authority, you can work with them and use SDM informally to build upon the decision-making skills. Guardians should be doing what they can to promote your self-determination anyway. And you may be able to go back to the court to show that you can make your own decisions and also have your rights restored.
Awesome. So these are some resources. They'll go out with the slides. There's the Maryland actual bill text. I used to tell people this with the surrogate decision-making law, print it out, if you have it, bring it around with you to the doctor's office if people know what you're talking about. It's always a good idea to show them. And DRM has some great resources, and then we've included some additional resources here. So I know we have a couple questions. I know we're a little short on time. If it's okay, can we quickly take those if we run over?
Absolutely. And can I ask you to stop sharing so we can sort of come back in? I can pull up is that okay? Okay, excellent,
Absolutely.
excellent.
Yeah.
All right, so then we'll open up your chat. I presume you already have it open. Let me see.
good.
I think you said you already know what questions you've
Answered.
go right ahead.
Yeah, I think we talked about the example of using a power of attorney instead of SDM, kind of the two different roles of those two different documents. It's different than informal collaboration. It's not that different unless you have a formal agreement. My daughter's legal guardian, and we relocated from another state to Maryland, transferring the guardianship. Ultimate goal is to have supported decision-making, working with a lawyer, but I'm concerned hearing the guardianship is difficult to change. So, I think, what DRM has done, what's been like a main push, what poor Randy and Sandy have been doing, is educating judges on this. We were very fortunate when the law passed to actually have the support of the Maryland judiciary. The Maryland courts don't support they typically don't support a lot of legislation that they don't produce themselves. So this is an education. We're trying to educate judges about this, and the guardianship law in Maryland requires that guardians themselves do an annual report, and in that annual report, they have to indicate whether or not they think that the guardianship should continue. If they don't think the guardianship should continue, then the court should hold a hearing. So that I think that if you're already guardian, there are mechanisms, legally already, to kind of trigger that review. And I think, a lot of it is education. That's a big part of it. Randy, or Sandy, I don't know if you have anything else to add. No. Another question of whether the person doesn't want help but needs help, can they refuse? Is guardianship the only option then? So it's a really good question. I think, when you're talking about more acute situations, a supporter isn't going to be able to make a decision for a person. That's where things like, that's why things like a power of attorney are particularly helpful, right? Because there'll be a time in all of our lives where we will not be able to make a decision for ourselves. And so having that option is important. So, I think that, you could maybe look at surrogacy in that option. If a person really isn't able to make a decision, can you use surrogate decision-making? There's an exception where surrogates can't make decisions about mental health treatment, which is a big carve out. But, assuming it's not something related to that, then surrogate decision maker might be able to help. But I think part of it too is, how informally, how do you get that person the support that they need? I think, some of what I've done is supported decision making is like mental health first aid with people when they're really worked up, when they're really focused on something, is trying to de-escalate the best they can and try to, have a plan. So, I don't think guardianship is necessarily the only option with just the facts that we have in that scenario. But it does highlight the importance of some, advanced planning and trying to do things before. I don't know if you have anything else to add, Randy. We can keep on going. Share the link in the slides. SDM be an alternative to leaving your inheritance to a person with some disabilities in a trust? So I think that, it's when we don't do a ton of work in special needs trust, but I think that's a kind of technical question. It's going to depend on the trust itself, because I know that generally once money goes into the trust, the person actually doesn't have control over it. They request reimbursements, and then the trustee gets to decide whether or not they disperse those funds. So you could, in theory, if the person wanted to, you can't set up a supported decision-making agreement for someone else. The person has to say, this is who I want to help me. But if a person wanted support to, think through how they access money from a trust, that's something that they could use it for. But again, the trust itself is a great mechanism if you're worried about financial exploitation or something like that, because the person will not have direct control over that money. It'll always have to go through the trustee. Assume that a decision has been made with the appropriate interaction between the person and the supporter. Is there anything that prevents the supporter or the person from asking this supporter to actually implement the decision? So unfortunately, there is just a hang up in the language when we pass the law. Supporters can't enforce decisions made by the adults. They can't go buy the car for the person. They have to be able to do that themselves. So they can't, the legal term is effectuate a transaction, was the language that got everybody all tied up. So so there is that restriction. Working with a client will need to appear in civil court and herself may be in make decisions related to the case for the person who's supporter, recognize support help.
And there was an additional note that this was with federal immigration court. So I'll jump on. You've been
you should.
I finally caught up to where we were with questions.
Sorry.
Yeah, so that's going to be very specific to that court. So whether the court, if the person needs an accommodation of a supporter, there should be some kind of court administrator that can assist or advise on submitting a request for a reasonable accommodation or documenting the need for the support person. But as it comes to representing the person, a supporter cannot, essentially be somebody's attorney before a court. And so the court, has its own procedural rules that are specific to federal immigration court, which I do not practice in. But generally speaking, formal courts will not allow a non-attorney to represent or advocate on behalf of a party.
That's a great question. So I see just a couple more. Set up my will, special needs trust and able account. That's awesome. All things do. Then my daughter can make decisions with support. She also needs help with the technical part. Mail in appointments. Does she need a case manager or something else? So, I think to the extent that without kind of more facts, it's hard to tell whether or not somebody needs something specific, but I can say case managers, those informal supports are kind of always helpful as well if they're connected to services. That might be part of it. Supported decision making is really about building community. Sometimes people say, oh, this person has no one in their life, and that is really sad, and that's a failure on the community to really step up. So I think to the extent that be cultivating those relationships with folks, a case manager or point person is always helpful, depending on the services that might come with a case manager. But I think that that's always, it's an important thing to kind of think about, and for her to kind of talk through how she wants to make decisions down the road and be talking about that in advance, because you don't want to get to a point where none of us are great when we haven't been thinking about a decision and then all of a sudden out of the blue you're forced to make it, right? Being able to think about things in advance, I think is helpful. And I think that the last one is should have a financial power of attorney, at least with SEMs, and doesn't understand money. Currently currently working on it. So I always recommend people have a person's able to make a power of attorney and to select who they want. It is always a good document to make. there'll be a time in all of our lives where we will probably need one. So it's good to do now. It's always good to have that backup. And certainly the two power of attorney and supported decision making can work really well together. So I think that those are two tools that really do well. Okay, I think this
I
is my
think that's wonderful.
speed questions. I feel like
Yes.
it's
Well, I want to thank Megan, Randy, and Sandy for their time tonight and their knowledge and expertise, and we're grateful to have had this opportunity. As a reminder, this has been recorded. You'll have an opportunity to access that recording from our website. I think Neil might even email it out to everyone. So thank you all, and thank you again very much. Bye-bye.
Have a nice evening, everyone.
Hi, everybody. Thank you.